Good evening, hello and welcome. You're watching Viewpoint. I'm Anusha Soni. The proposed changes to the Indian Penal Code, Criminal Procedure Code and the Indian Evidence Act. You'd remember these important provisions that were laid down on the floor of the House and were referred to a select committee by none other than Union Home Minister Amit Shah. These proposed changes have raked up their share of controversy. Apart from political jibes over the intent of these reforms or changes being proposed, the substantial changes that the three proposed laws that they bring in are also under intense debate and scrutiny. Home Minister argues that with these changes, the law of sedition will be scrapped. One example that I give you. Mind you, the law already has been put in abeyance by the Supreme Court of India. Apart from that, the introduction of a penal provision against mob lynching, addition of a new chapter that enlists crimes against the state, the jury is still out on whether these are actually sweeping reforms, as the government claims, or this is just the old wine in a new bottle. We discuss, we debate threadbare about the proposed changes that the government is talking about and whether it is in line with the constitutional evolution of modern democratic India. Our top focus on Viewpoint tonight.
तीनों कानूनों में गुलामियों की निशानी से भरे हुए कानून, राजद्रोह को कंप्लीटली हम रिपील कर रहे हैं, कंप्लीटली रिपील। यहां लोकतंत्र, सबको बोलने का अधिकार है, राजद्रोह को हम कंप्लीटली रिपील कर रहे हैं। मान्यवर, सबसे पहला चैप्टर इसमें आएगा महिलाओं और बालकों के साथ अपराध।
हमारा जो प्रतिनिधि होगा, कांग्रेस का जो प्रतिनिधि होगा, इंडिया का जो प्रतिनिधि होगा, वो अपने विचार बाहर नहीं रखते। भाजपा की जो गलत नीति समुदाय को, वर्ग को, उनके सबके हित के साधते हुए हर भारतवासी के हित का सुझाव दें।
प्रमुख चुनौती ये है कि क्या इन संशोधनों द्वारा हम ऐसे कानूनों को लागू कर सकेंगे या इस प्रकार से कानूनों को लागू कर सकेंगे जो न्याय संगत हों मगर जिनका दुरुपयोग ना हो।
So we break down what exactly are the key changes that the government is talking about. What dominates the public discourse? What dominates the legal discourse right now is the big announcement from Union Home Minister Amit Shah that we're scrapping the sedition law. Well, the law is already put under abeyance by the Supreme Court of India. The government had to agree to that. So right now, what the Union Home Minister is talking about is that it will be completely done away from the statute books. It will no longer exist. But in its place, there is a new chapter, Chapter 7, that has been introduced that talks about the crimes against the state. Now, the debate is whether this is far more stringent than the old sedition law, or this is just renaming of a provision that was existing and you're just repackaging it. For us to answer those questions, for us to understand the different aspects, it's important to look at the old law versus the proposed law. One thing to understand in the old law, as far as the old law is concerned, is you have to talk about the language. The manner in which any provision is worded under the penal code defines and details whether it's going to be used or misused. The vagueness of the language, hatred, contempt, feelings of disaffection, these all reek of colonial times. It is true that even sedition law has gone through changes right after it was used on Bal Gangadhar Tilak against during the freedom struggle. But even in the present form, 124A has these terms that you see on your screen right now. Now, in the new chapter, which enlists certain provisions which talk about waging a war against the state, they talk about collecting weapons, inciting violence, and various other methods and tools that can be used against the elected government of the day. Under the old law, there was no clear definition of offense against the state. Disaffection. You could not like your government. You could have bad feelings, quote unquote, towards your government, and you could still be a good citizen. That's what the democratic temperament is all about. The proposed law talks about, these are the words it uses: conspiracy or use of criminal force against the government. Many would argue that compared to the word disaffection, That's a better language. Now, the section was termed as vague and arbitrary by the Supreme Court. I reiterate here that there was no Constitution bench judgment or there was no judgment of the Supreme Court that said so, but these were oral observations that had repeatedly come in from the bench. Attempt to excite armed rebellion and fueling separatism. These are clear terms that the proposed law uses, and I wonder if there are people who can disagree whether these things should be legal in this country or not. The old sedition law was open and prone to misuse due to the colonial language. The vagueness of the language made it more prone to misuse, and activities against the president and the governor's office. This is once again one of the provisions under which the state can take action against you. Now, as we talk about the old law versus the new law, there's one more aspect that we must understand. That is that dissent, sedition was used to curb dissent, political dissent in this country. Is that possible under the new provision? We'll take that question to our panelists as and when they join. But let's come to the safety of women. This is one aspect that was talked about on the floor of the House in Parliament before it was adjourned. Death penalty for rape of minors below the age of 12. This is unprecedented, this is new, this is tightening of the present law as far as sentencing is concerned. Minimum 20 years of life imprisonment against gang rape. So the substantive law on rape in our country is already very strong. What the government is trying to do is rework on the sentencing bit. They're also talking about speedier trials. They're also talking about a time-bound investigation, something that repeated Supreme Court judgments have talked about, law commissions have talked about. But whether they are going to make it mandatory is also dependent on number of courts and police reforms that we have in this country. The key impact. The government criticism cannot be dubbed as sedition. That's clearly the intent which the Supreme Court had highlighted. There are also safeguards to prevent the misuse of sedition law, and this is something most of the experts and proponents of free speech in our country have been talking about. There are also exhaustive definitions that cure the defects of vagueness, especially pertaining to 124A. That's what the government is arguing. And as far as sentencing provision is concerned, when it comes to crimes against women, it is expected that with speedier trial, stringent sentencing in our country, all the crimes against women, especially a heinous offense like rape, will be further deterred. But the jury is still out, and we present to you our panelists, our esteemed panelists who are joining us on the broadcast. Mr. Aman Lekhi, who is the Senior Advocate of the Supreme Court of India and former Additional Solicitor General of India, is joining us on the broadcast. We also have Mr. Rajiv Pandey, who is the spokesperson of the BJP, Arshpreet Kadial from the Congress Party, Mr. Brijesh Kalappa from the Aam Aadmi Party. He is also an advocate. Dr. Kapil Sankla, who is a Senior Advocate, is also joining us on the broadcast. Mr. Lekhi, I want to come to you first. Your thoughts on what the government is proposing. Are these actually the groundbreaking reforms like the Home Minister claims it to be?
Well, I have serious reservations both about the method and the justification for this reform. I'm never against reform, and as far as law is concerned, it's evolving and needs to be changed to align itself with the circumstances as they prevail and understanding of justice which is current. However, what the Home Minister said is one, that these are colonial laws and this is a method of emancipation, shorn of unnecessary details. And I have very serious reservations about that because as far as the laws are concerned, the suggestion that they were in any way less democratic than the changed laws are meant to be is egregiously wrong because all protections of due process were in fact available. And with passage of time, there were changes also which were made. We have law commission, we've got special commissions, we got recommendations, we got the court, we got evolving jurisprudence. So it's a suggestion that, see, we were actually in the pits where law is concerned, and this is a liberating measure in which we will be exposed to a system which hitherto we are not aware of, is completely wrong. I've got very strong objection because that creates a prejudice towards the existing system.
That creates a prejudice. That's a very strong argument that you're making. I want you to make another opening remark before I go to the BJP and the Congress. Sedition, that particular provision is dominating the headlines. Do you believe that the government has actually done away with the spirit of why sedition was criticized by the Supreme Court or by the proponents of free speech? Or the present proposed provisions are sedition in a new avatar?
Well, my views on sedition are well known. I mean, I'm in the minority of people who actually is in favor of retaining this particular law, particularly in this circumstance. But what I want to bring into focus is the duplicity of the government here. Now, the government has been in the forefront defending sedition and said that, okay, as far as this particular aspect is concerned, necessary. And they're undisputed that certain aspects of which are actually necessary. I'll be in one with the government where that's concerned. But now the government is on defensive and is trying to use this so-called deletion of sedition to justify these three laws. Now, I call it duplicitous because it is not as if that particular provision has been removed altogether and is non-existent.
Okay.
Or that the option the government to deal with seditious activity is no longer there.
Right.
It is there, yes, but in an incarnation it is different. And that incarnation may actually make this particular offence slightly more amorphous than 124A, which had tailored into it rather precise limitations so as to ensure its misapplication to dissent. Sedition was never meant to apply to political
dissent in our country.
There was enough protection in that particular provision to ensure that it does not so extend. The problem with the provision was not the provision but the application.
All right.
And the application is what created this kind of furor.
Yes.
But unfortunately, the manner in which the government is going about its business today shows that while nominally removing it from the section, the intent to misapply the particular provision is as live today as it was then.
I think you have said that in very clear terms. Rajiv Ji, the intent to misapply the provision is as clear, evident and alive as it was earlier. That's what Mr. Aman Lekhi is saying.
No, I completely disagree with my friend, Mr. Lekhi, who is senior in the bar with us. First of all, he is saying that the new system will be considered as a prejudicial system of existing system. What existing system has brought in this country? Tendency of more than 5 crore cases? What I am trying to say, he should clarify what is the issue, what law is brought in all these 3 new acts or bills right now, these bills, that is prejudicial to the criminal jurisprudence or the system, judicial system. What I am trying to say, all these issues which were being debated in this country, like section IPC 377, gone. It is about the Rajdrah, that is gone. Reason, if somebody conspire to overthrow the country or break the country, that will be there, treason will be there. But Rajdrah is gone. What about the criminal defamation that at least now you can do some community service? Many things has been brought and the things which was not helping. Like I'll tell you one thing.
Right.
If any crime, one car is attached, that car is lying in a junking. Now all these things I was going through, that new Sanhita, in that it is there, that all the goods which is attached, that can be sold during the trial. The trial has to be completed in a particular time period. So all these 3 things which are important, if you see, I talked about 377, I talked about the Rajdrah, I talked about the crime against women. You know, crime against women, rape to the kids is now more declared more henious. Minimum 20 years life term for gang rape or death. Even many things are there which we can discuss. And the most important point is that in IPC there were 511 sections. Now it is 355 sections because many crimes were not. Just one second.
Yes.
I'm only coming on very important point. Like terrorism, it was not fully well defined. Now in this act you will find what is terrorism, what is treason, what is the difference between Rajdrah and Deshdrah. You cannot do Deshdrah. You can oppose government, not the country.
No, you're
what
right.
Is wrong
you're
with
right.
that?
You're right.
And only last line, which he said, it is the prejudicial to the existing system. Existing system has not delivered justice in this country, sir. The justice is available for the rich people, not for the common man. So there should be a timeline. There should be a fixed timeline so that the courts will have to work and deliver justice.
No, Rajiv ji, I think I will pick on the last part of what you just said, that justice has been a luxury of the privileged in this country. You're right about that. And the colonial baggage cannot be shed till every person, irrespective of their caste or financial status, has equal access to justice and institutions of justice in our country. The argument that Mr. Lekhi was making is that the manner in which these reforms have been presented makes one seem like everything is going to be okay if these 3 bills are passed. The reality of the matter is, if there are no judicial reforms in this country, if the number of judges at the local level are not increased, if the police reforms are not implemented in this country, no real change will really come in. I want to bring in Ashpreet also on that point. Ashpreet, barring the politics of it, and you're a lawyer yourself, what are the substantial points on which you disagree with the 3 proposed bills that have been tabled in Parliament?
Thank you very much. Kindly allow me a minute and a half uninterrupted. As far as this entire exercise is concerned, the entire criminal law overhaul, the Bharatiya Janata Party is simply doing it in order to leave an imprint on our social, cultural, legal and political aspects of the country. That is what their objective is, because the objective behind it is a handful of changes which could have been taken care of by a handful of amendments. Just a handful of amendments would have sufficed. They did not have to entirely change the whole thing, beget a complete criminal overhaul of the criminal justice system, because I'll tell you why. I'll give you an example. If we were to renovate a room in our house, we'll renovate the room. We will not bring down the entire house and start building it from scratch. That is what the Bharatiya Janata Party's government has been doing, simply in order to leave an imprint. And what happens due to this is, we waste our time, we waste our energy, we waste our resources, we waste our money and many more things. And due to this, there would be complexities, there would be disruptions. There are so many trials that are happening, tens of thousands. It would beget so much complexity for those trials to be decided upon, and there would be implications to it. So the Bharatiya Janata Party is accustomed, to not consulting with the stakeholders like they did at the time of farm laws, and then they had to, after wasting a year, they had to take it back.
But
I think history repeats here. Number three, a very important point. You see, the Bharatiya Janata Party in the last 70 years did not ever raise this issue. If they have been in the government from the last 9 years, and if they say this was also wrong, also bad, then why have they been a party to it by not doing anything in the last 9 long years? They have no answers to it. Last but not the least, I just have one thing to say to the Bharatiya Janata Party, that if you really were all about reform, then there would have been a definition of hate speech. There is no definition at all. There are many cases that are being registered. Nothing about it. Number 2, there would have been a comprehensive law with regards to custodial tortures that have been happening. Number 3, the Honorable Supreme Court has categorically opined against sedition law, and the Bharatiya Janata Party is undermining the Supreme Court, something that they've always done, by strengthening the sedition law that we have in the country. And the Bharatiya Janata Party.
So I gave you 1.5 minutes uninterrupted, the time that you deserve. Rajiv ji, I'll come back to you. There's one point that I want to clarify with Ashpreet. Yes, Rajiv ji, go ahead. Make your point, then I'll go back to Ashpreet.
Yes, only I'm saying 111th and 120th Standing Committee report has recommended that there should be a reform. And then 146th report of a Standing Committee of Home Affairs have recommended that why these kind of pendency and these kind of denial of justice is taking place and how we can improve. And that's the reason that all these 3 new laws are being made. What Congress spokesperson is saying, that 2 things are not added. Right now it is going to a standing committee. But what is the problem that many things are deleted?
I believe hate speech, like sedition and defamation, is a double-edged sword. Like sedition has been misused in this country for curbing political dissent, so can hate speech be. And I'm sure Ashpreet is aware this is a very thriving debate in countries like UK and US, that to what extent law should interfere. The argument is that hate speech and the boundaries of hate speech are very, very fluid and they continue to evolve. I want to bring in Mr. Sankla and Mr. Brijesh Kalappa as well, the 2 legal minds on the panel who are with us. us on the broadcast. Mr. Kalappa, first to you. Do you agree with the criticism that the opposition is mounting? And I want to add one more aspect to it. The DMK and various other southern parties are talking about the language. The way it is being worded is primarily in Hindi, derived from Sanskrit, of course. But the terminology or the nomenclature is in Hindi. And that's another layer of politics around this entire issue. Mr. Kalappa, please.
First, Anusha, is the element of surprise. If three major laws in this country are going to be changed, I think it's very essential for the entire country to be speaking about it, because every citizen in the country has a view with regard to the IPC, with regard to the CrPC and to the Indian Evidence Act. Now, where was the need to have an element of surprise and suddenly bring it to the Lok Sabha and then introduce it? One, if the government had a sincere intention, I think they should have first ensured that, look, everybody should have spoken about it, and then everybody should have had an attempt or chance to make a contribution to the changed laws. One. Two is this element of grandstanding. You make changes in less than 1% of the law, and then you behave as if you're changing the law in its entirety, and a new law is coming into effect in 2023 that is going to change the fortunes of all Indians. I think this kind of a grandstanding ought to have been avoided, completely avoidable. Even Lord Macaulay, when he wrote the Indian Penal Code and the other laws, he didn't have it was not an attempt to write himself into history. That became history by the fact that, the manner in which it was operated, and people across centuries have appreciated the kind of laws that Lord Macaulay has brought. So you don't enter into history. You don't enter into history by intending to write yourself into history.
Okay.
So I think this entire attempt
that
of
point
Modi Sarkar to...
Mr. Kalappa, that point of Rajiv ji, I'll come back to you. I'll give you the time to respond. I'll give you the time to respond to all the criticism. I know you have a lot of points to respond to. But Dr. Sankla, coming to you, the argument of grandstanding yes, Mr. Kalappa. Yes, 30 seconds.
I think you
Sorry. Please finish your point.
Yeah. So I was only saying now this grandstanding could have been completely avoided, right? Now the third part is there are of course some good things. For instance, the new law speaks about community service, which is most welcome, because you don't need to criminalize a person. You can ask him to do some community service, and in the process he feels good about himself. This is something we have been speaking about all along. So this could have been done, but without changing, doing this whole exercise of making it look as if it's larger than it actually is.
I know.
And the important part about this is the question you asked me. The question is that why avoid calling it the Indian Penal Code? And this is just a month later, after the entire opposition takes on the name of India, and then you have the Bharatiya, so on and so forth. I think this is clearly an attempt to kind of take India away from India. And I think this exercise also was an exercise which should have been avoided, because ultimately India is bigger than all of us, bigger than political parties.
Dr. Sankla, we've had the privilege of speaking about this issue on Friday as well.
Very proud of.
I'm taking that point to Dr. Kapil Sankla as well. Dr. Sankla, we spoke about this on Friday as well, and I want to reiterate that point. But I believe there's one thing which is recurring from the likes of Mr. Aman Lekhi or what Mr. Brijesh Kalappa is arguing, or even what was argued by the Congress party, that there is an element of grandstanding. And as if the government is entering into it with the intent of registering themselves into history, which may not be per se bad, but if that takes away the focus from the substance of the reform, then it can be a problematic scenario. Would you agree with that criticism, Dr. Sankla?
Actually, I can just talk as a lawyer.
Sure.
And probably a person who's on the dais and arguing a matter, or in the parliament speaking. The person's personality might probably overpower or be at the same level as whatever bills are being brought. But as a lawyer, let me just point out very quickly from what every person before me has stated. You see, they're saying that not many acts have been changed, sections have been changed, only 1% has been modified. Mr. Lekhi had his own points. I just want to point out that you see, over the years since independence, there has been a lot of changes in CrPC and IPC. That's right. But those have been all amendments, either, and hundreds of amendments, or there has been judicial precedents where the judges feel that there is a vacuum that needs clarity and therefore has brought along a judgment and said till the time the legislature, which is bound to bring the legislation into place, does not bring the law, till that time this will be filling the vacuum where the law isn't there, right? So there have been a number of judicial precedents which have also caused confusion. The biggest is how long can the police arrest you as far as remand is concerned. The law is 15 days, but is 15 days going to run concurrently or in piecemeal manner? Or there has been judgments pertaining to what happens when a sick, infirm or a senior citizen is arrested. When will he be granted bail, or can he be granted bail at the first instance and anticipatory bail? So there have been a number of judgments over the years, and there are also contradictory judgments. So I think it was high time that all of that was consolidated. And one of the gentlemen said that people were not taken into consideration. I'm sorry, this CrPC amendment proposal came 2 years back. Many lawyers like us from the criminal side wrote our 2 bits to the government and on the papers and through you. And I think all of that has been taken care of. For example, the issues pertaining to bail have been clarified. I was the one who stated that, the entire inquiry and investigation should be recorded. There should be body cams. That has been brought into the bill. There was a proposal that we had put in that the laws should be made as far as rape and offences pertaining to the body are concerned should be made gender neutral. There's a talk to do that, and various other instances. As far as I see, what has happened is that the government has seen all the judgments over the years, seen what those judgments basically were filling the legal vacuum or the judicial vacuum, the legislative vacuum, and sought to fill that up with this new act or new bill in place. So I really don't understand about the grandstanding bit. I do think that as a lawyer, there has been massive changes that have been brought in, and those were changes that we were already talking about for a number of years because the Honorable Supreme Court was talking about it.
And I believe the Home Minister also said it on floor of the House, how various universities, lawyers like you and various Supreme Court judges were consulted during this process, and the fact that it has gone to a standing committee, the fact that there would be most likely a debate on the floor of the House makes it more amenable, and avenues like this, the present debate that we are having is
and it was all online, in fact.
Yes. Mr. Rajiv Pandey, you were trying to make a point. Please go ahead.
Just I wanted to add one point. Is already our senior lawyers on the panel, Dr. Kapil, has explained that it was consulted 2 years back, and many people have talked and shared their views. So that point is already being discussed. Second point, I am unable to understand how such a senior advocate, Brajesh Kalappaji, is saying that only 1% change is there. In IPC, there were 511 sections. Now it is only 355. Is this the change 1%? I am unable to understand. Second point, in CrPC, for which the act is coming, that means Sanhita Suraksha, the Bharatiya Suraksha Sanhita, that has more sections because there were many issues which were untouched.
Rajivji, I have a question which is not about the Congress, BJP or your critics, but as a student of law and a citizen of this country. It is great that the government is finally talking about trials to be in a time-bound manner in this country. That has been a long pending demand. But the reason why trials don't happen in this country in a time-bound manner, and Mr. Brajesh Kalappa, Dr. Kapil Sankla, and you yourself being a person in public life would know that one of the biggest problem is not having enough judges in this country. The other big problem is not having enough police personnel in this country. 1 second, sir. So, if we really want to shed our colonial baggage, like the government is arguing, we need to work to the root of the problem, which is to have more judges and police officers in this country.
Anusha ji, I am telling you, you are absolutely correct on these points also, like police reforms and the number of police and number of judges. Now, if you see, you have reported from Supreme Court, and I have been on the panel with you for several times. Now, if you see the number of judges in the High Courts and Supreme Court is almost in every state is about to become full. Whatever is their strength, judges' strength. What I am saying, what is your suggestion? And people know this, that without doing this, it is impossible to achieve the target that a time-bound program, a trial should complete or a case should be over. So after doing this, government is going to look into that also.
Okay.
And second point, as a practicing lawyer, I can say, many times matters are getting adjourned time and again because of some other reasons also. If you go to a trial court and see how many matters are getting adjourned without even being called out. So once the time frame is given to a judge, to a court, to the fullest.
I think that's going to be a debatable proposition. That can you really give a time-bound manner? I want to give closing comments to Ashpreet Kadial and Mr. Brijesh Kalapa. Mr. Brijesh Kalapa, please go first.
First is, Anusha, I was only pointing out that if 511 sections, some of them have been joined together, some of them have been juxtaposed, so on and so forth. I think, saying that, 511 sections have now become 360 or something it's not going to take away from the fact that only 1% of changes have actually been effected, right? So making merely the exercise of reducing the number of sections by joining sections is not going to take away from the fact that not much work has been done. One. Two, if there is a selective exercise in consulting X, Y or Z, I don't think this is a large-scale exercise. That's exactly what I pointed out. I think if you're going to have laws changed in the country, have a large-scale exercise, involve everybody. And that is what I was trying to say.
But Mr. Kalapa, if the consultations are online, if they are open, do you have suggestions? Do you have suggestions how the government can make it more open?
May I?
Ashpreet, I'll come to you. Mr. Brijesh.
There are bar councils across the country. There are bar associations across the country. Every single lawyer has a point of view, and these laws have to be changed by very.
Sir, with due respect, if you just read those draft proposals, it's written there, and the Home Minister also said it that the bar councils were consulted. But we can always have a wider consultation. Ashpreet, as you give your closing comments, the argument of the BJP is that this is criticism merely for the sake of it, without any substantive value. Ashpreet.
See, now I'll prove it to the people who are watching it and the people who are on the panel how it is a futile exercise just to leave an imprint. The gentleman who was in favor of the entire criminal law justice system overhaul, let me tell him one thing. Let's talk of the Indian Evidence Act, which has also been overhauled. Now, what is the change? Back in the day, the total sections were 167 in totality. And now there are going to be 170 sections. So basically what's happened is one new section has been added and 23 sections have been changed and 5 have been repealed. Now, why could this change not have been catered to by or via an amendment? You could have inserted all these changes through an amendment. Why did you have to touch the things which did not require to be touched? We did not require to be overhauled. So this goes on to suggest that the Bharatiya Janata Party is simply trying to put an imprint and nothing else apart from that. Number two, you see, the Bharatiya Janata Party says that we are doing it all in order to ensure speedy justice and in order to take care of the contemporary needs of the people. Right. Now, if this was a fact, then Manipur and Haryana, no incidents would not really have happened. There would have been justice and there would have been catering of the contemporary needs of the people, which did not happen, which we could not say. Number 3, the sedition law, they say, has been repealed. Now, what could be a bigger eyewash and a bigger lie than this? They say the sedition law has been repealed. I mean, the innate nature of sedition law has been strengthened, and they are saying that it's been repealed. Now, the Bharatiya Janata Party is accustomed to lying openly, blatantly, and this is one.
That's all the time that I have. But Ashpreet, I appreciate all the time that you've given. Sorry, Dr. Kapil Sangla, that's all the time that I have. But as I close this debate, and I thank you all gentlemen for joining us on the broadcast for this intriguing and interesting debate.